Ladies and gentlemen, a cordial welcome to our webinar today. I welcome, of course, all the participants in Japan, in Austria, at our Außenwirtschaftscenter Tokio, Advantage Austria Tokyo office, your office in Japan. We see there are still people signing on. I'm Arnold Ackerer, working here as a deputy head of Advantage Austria Tokyo. As you can see, we had a real big turnout today. It's more than 100 people signed up. And I will start a little bit with the introduction of the house rules today. As every one of you saw when you signed in, this webinar is being recorded. That's of course also for your benefit. We will later send you the recording of the webinar, excluding the Q&As. So it will be the presentations, the start and the presentations, not the Q&A. That also means you will get the slideshow, meaning the PowerPoint presentations that our speaker has prepared. And there's no need for you to take screenshots or notes of the things that are already presented. One thing is questions. We very much appreciate questions. Please, already during the webinar, write your questions in the chat. That's the easiest way. I have my colleague, Mrs. Ihara, who is our legal expert and will come online later for the Q&A part. She will sort a bit through the questions, depending on how many questions we get over the course of the webinar. She will then present them to Mrs. Tsukamoto, and for all the questions that we might not be able to answer immediately, or we will either come back later or answer you in writing. So as I said, we have my colleague Junko Ihara, who is working as the market officer for legal and tax issues at our office in Japan. And we have today outside expert Sayako Tsukamoto-san, who is our partner from City-Yuwa Partners. She's an attorney at law and has been here for many, many years. Thank you, Junko, for coming online. Thank you, Tsukamoto-san. I will just add a few more remarks about the treaty. As many of you might have seen it, you can stay online, no problem. It just takes a few minutes. I will not take away a lot of time from your presentation. So it's just a bit about the timeline. Since there's always a question of the agreement has been signed, it has been ratified by the two parliaments. The first initiated negotiations were almost, or not almost, but really 20 years ago. And now we are in this stage where we have the agreement signed, ratified by the parliaments, but we are waiting basically for the two administrations to negotiate the procedures, the forms, how you can apply, all those things. And we just talked today, that is actually Tsukamoto-san, thank you very much. We just talked to the agencies here also, and there's a very different experience between different countries, how fast it works between, getting this signature, getting the parliaments ratified the treaty, and then actually having the day or when the agreement takes effect. So we had some cases that some countries took a very long time, a few years even, some where it was all done within 1 year. So in that having said, we strongly hope that, of course, this agreement will go into force very quickly. We hope something 2025, but of course there is no guarantee when it will actually enter into force. That having said, it's important for us to keep in mind that today this webinar is mostly to preview about the principles, the agreement, what it states, what cases it can be used for, what the benefits are for the companies. Today we will not be able to answer explicitly, you have to use form ABC to apply for that and that, you have to go to that particular agency to file your claim. That we will not be able to do today yet. So those things I wanted to caution everyone, but of course, another caution that we saw already when we talked to the agency is like that many of these questions that we received, and we received a few ahead of the webinar today, are of course questions that can be only answered case by case. So there are always difficulties in calculating benefits and so on. These things are case by case. With all having said all that, I'm very happy to now introduce our speaker for today, Ms. Tsukamoto, as I've mentioned several times. She is a partner and attorney at law at City-Yuwa Partners, has been practicing business, corporate, and other laws relevant for business and companies for more than 12 years now. And being an expert in that field, I would very much like to hand over the presentation to Ms. Tsukamoto. And yeah, Ms. Tsukamoto, please, when ready, share your screen.
Thank you very much, Mr. Akara. Let me share my screen. Okay, great.
I'm sorry to jump in shortly. If you have any question during the webinar, please do not hesitate to post the question using the chat function.
Okay, thank you very much. So good morning and good afternoon, everyone. My name is Sayako Tsukamoto from City-Yuwa Partners in Tokyo. And as introduced by Mr. Akara, I provide a wide range of legal services to individuals and companies doing business in Japan, and focusing on labor law and corporate law and other areas. And as the head of our firm's German practice team, we have worked on a variety of legal matters for clients in German-speaking countries, including Germany and Austria. And today I will talk about the basic structure and key points about the agreement between Austria and Japan, and some practical topics for navigating cross-border social security challenges. So this is today's agenda. And from number 1 to number 4, I will talk about the purpose and background and current situation of this agreement, social security agreement. And number 5 is about key points. And number 6, I will touch on the practical procedures that are expected for now. And number 7 is about the potential risks and disadvantages of this agreement that may arise. And number 8, I will talk about some questions that may arise after the execution of this agreement. So first, purposes of the Social Security Agreement. The Social Security Agreement is the agreement between two countries to address social insurance challenges, and it simplifies social insurance for internationally mobile individuals. And yet the main important purposes of the contents are these 2 points. These 2 points. The first one is eliminating double contributions. So a situation where the expats have to continue paying social insurance premiums in both their home country and their host country. This agreement will solve such problem by eliminating double contributions. And the second point is ensure pension eligibility. And so there is a problem where people who have paid pension insurance premium in the host country cannot receive a pension because they do not meet the minimum enrollment period criteria. And I will elaborate on these points later. And in doing so, this agreement will support economic cooperation between two countries and enhance cross-border flexibility. So from these purposes of this agreement, we can see that the agreement will have a big impact on practices about expats. This map shows Japan's status of agreements with other countries. So Japan have been concluded the social security agreement with more than 20 countries. And the first one was Germany in 2000. And the latest one is Italy in April this year. And here Austria's status is signed this year. And naturally, social insurance systems differ from country to country. So as a result, the scope of the agreement, that is, which insurance are covered and the effects of the agreement, this differ from country to country. And this is differences from social security agreements between Japan and other countries. I have only picked up out a few countries here, but there are actually many more. But as you can see here, the scope of each agreement differs. So about totalization of coverage period, some countries have some agreement with some countries include this provision, but agreement with Italy doesn't include. And so as you can see, each agreement covers different social insurance. And as for Austria's status of agreements with other countries, thanks to EU social security regulations, a coordinated arrangement exists within the EU and the EEA, as well as Switzerland. And also for Austria, Austria has also concluded social security agreement with many countries already, as listed here. And as I said, yeah, these agreements vary in scope. So some cover only specific areas, and some, such as pension insurance, and others provide more comprehensive social security agreements. Yeah, and about background and process for the signing, as Mr. Akara has already mentioned this point, I would just briefly mention about this topic. So from Austria to Japan, there are about 80 Austrian companies operating in Japan, and there are about 730 Austrians residing in Japan. And in Austria, 140 Japanese companies operate in Austria, and about 3,200 Japanese residents in Austria. So many individuals and companies may face problems with double payments and eligibility issues currently. As for the effective date, yeah, signing was done this year, but effective date is not yet decided. For your information, the most recent social security agreement Japan signed with Italy came into effect this year, but it was signed in 2009. And it is said that the reason it took so long was because of the prolonged negotiations due to differences in the legal systems of the two countries. So, but on the other hand, for example, the Japan-China Social Security Agreement came into effect the year after it was signed. So it depends on the country and the situation, and so it is difficult to predict the effective date. But this is planned in or after 2025. Next, I will talk about key points of this Social Security Agreement. So one of the key points is elimination of dual coverage. And these are examples of double contribution scenarios. From a Japanese perspective, in cases where an employee is sent from Japan to an Austrian branch or subsidiary, if the Japanese employer continues to pay their salary after the employee has been sent, the employee will be obliged to join Japanese social insurance. And in that case, there will be an obligation to pay social insurance premiums in both Japan and Austria. This would also be the case when employees are sent from Austria to Japan. To eliminate such dual coverage problem, the Austria-Japan Social Security Agreement first sets out the general provisions, so in principle. So in principle, employees or self-employed individuals working in Austria or Japan are subject only to the social insurance laws of the host country. And then the agreement sets out the special provisions about temporary assignments within 5 years. Employees assigned to Austria or Japan for 5 years or less remain subject only to the social insurance laws of their home country. Mean that in principle, if the period of temporary transfer is expected to exceed 5 years, the laws of the host country will apply as a general rule. And exceptionally, if it's temporary assignments, then the laws of their home country shall apply. And as for self-employed individuals, they are subject only to the laws of their country of residence. So if the self-employed individuals is working in Japan, then Japanese law will apply. And in Austria, then Austrian law will apply. About the applicable social insurance contributions, so scope of this agreement. This agreement covers pension insurance, unemployment insurance, and medical insurance. However, it is important to note that for medical insurance, the laws of both countries apply. So in other words, as a result, employees will have to join health insurance in both countries. So if an employee comes to Austria from Japan, even if their stay is for less than 5 years, they will have to join Austrian health insurance in addition to Japanese health insurance. So let's look at the example of pension insurance, example of elimination of dual coverage of pension insurance. So if the employee is sent from Japan to Austria, before the agreement came into effect, regardless of the number of years spent in the host country, as long as the salary was paid in the Japanese employer, it is necessary to join social insurance in both countries. But after this agreement coming into effect, only Japanese law will apply if the period is 5 years or less. So in case of 3 years, only Japanese law will apply. And only Austrian law will apply if the period is more than 5 years, for example, 10 years. So as a general rule, depending on whether it is within 5 years or within over 5 years, one of the two laws will be applied. So there is no case of double application after the execution of this agreement. Again, this is about pension insurance. And for medical insurance, laws and regulation of both countries will apply. And yeah, it's the same in the case of the employee sent from Austria to Japan. And second key point is totalization of coverage period. The minimum years of pension eligibility is for Japan 10 years or more, and for Austria 15 years or more. So the issue is individuals may pay into social security systems, but fail to meet the required participation period. In other words, there is a possibility that there will be no return on the insurance premiums paid during the period if it is less than required participation period. And after the execution of the agreement, the coverage periods can be combined to meet eligibility requirements in both systems. And pensions are granted from each country based on the respective lengths of coverage in that countries. Let's look at the example. So if an employee working for a Japanese employer worked in Japan for 5 years, and then he was assigned to Austria for 12 years, and then worked in Japan for 4 years. Before the execution of the agreement. So currently, as the minimum period in Japan is now 10 years, he will not receive a Japanese pension in this case, because 5 plus 4 equals 9 and less than 10 years. On the other hand, as the minimum period in Austria is 15 years, he will also not receive an Austrian pension because, yeah, he stayed in Austria only 12 years. However, post-agreement situation, so after execution of the agreement, the payment periods in Japan and Austria will be combined. So 9 years plus 12 years equals 21 years. And as a result, the minimum period will be exceeded in both Japan and Austria. This is more than 10 years and 15 years. So, and the amount, so therefore this person will be eligible for both Japanese pension and Austrian pension. And then the amount of pension benefits in Japan is based on the amount of contribution made over a period of 9 years. And the amount of pension benefits in Austria is based on the amount of contribution made over a period of 12 years. Yeah, and this is also one of the key points. How is social insurance covered for the spouses and children of expats? So if a person, by the way, this provision was included at the request of Japanese side. So this is only applicable for the Austrian employees coming to Japan. And if a person temporarily sent from Austria to Japan continues to be enrolled in the Austrian social security system and exempt from joining the Japanese pension system, the spouse and children of the person who has been sent to Japan will also be exempt from joining the Japanese pension system if they meet certain conditions, such as being financially supported by the person. And as for spouses and children of self-employed people coming to Japan from Austria, they are exempt from joining the health insurance system as well. But even if a spouse or child is exempt from joining the Japanese system, they can still join the Japanese social security system if they wish to do so, and by submitting a notification to the government. And next point is about practical procedures. What kind of procedures will be necessary to receive the benefits of this agreement? But as Mr. Akara said, unfortunately, it is not yet clear, so details will be clarified upon the agreement's entry into force. And this information given here is basically based on the past agreements and is only a rough idea of the steps that are expected. And yeah, if the employee sent from Japan to Austria, the Japanese employer, first of all, submits an application for certificate of coverage to the Japanese pension office. And upon approval, a certificate of coverage is issued. And this person will bring this certificate of coverage to Austria. And the employee presents or submits this certificate to Austrian authorities if requested, or to explain non-enrollment in Austrian social security system. So this might be my general steps. And if the person sent from Austria to Japan, the Austrian employer submits an application for certificate of coverage, and upon approval, a certificate of coverage is issued. And after arriving in Japan, the employee either submits the certificate to the Japanese employer or keeps it on hand. And the certificate is presented to the Japanese pension office if requested, or to explain non-enrollment in the Japanese social security system. Yeah, for Austrian companies who send expats in Japan, just for your information, in Japan, there is an organization that has been delegated and entrusted by the government to carry out various operational tasks related to public pension, such as application or collection or record management or consultation and payment and so on. This is a Japan Pension Service, in Japanese, Nippon Nenkin Kiko, and it is the most important organization for pension practice. Just for your information. Yeah, and the next topic is possible risk and a disadvantage. We will talk about this topic because we receive a question about what kind of risks there are. So before this seminar, so I've listed a few things to keep in mind. So first one is continuation of corporate pension plan. So this matter is only relevant for Japanese employees sent to Austria. If an employee of a Japanese employer is expected to be sent to Austria for more than 5 years, they only need to join the Austrian social insurance system. However, if they do not join the Japanese employees' pension insurance, public pension insurance, they may also lose their eligibility to join a corporate pension plan, which is a pension that is set up by a private company in addition to the public pension, such as a defined benefit plan or a corporate type defined contribution plan. And there is a solution. In order to continue with a corporate pension plan, you can voluntarily join the public pension insurance and continue to join the corporate pension plan. And the next one is non-accumulation of pension participation. This may be only relevant for Austrian employees sent to Japan. So lump sum, receiving a lump sum withdrawal payment may prevent accumulation of pension participation periods, potentially affecting pension eligibility. So here, withdrawal lump sum means a payment that can be claimed by those who do not have Japanese nationality and who have paid national pension or employee pension insurance contributions while in Japan for a period that does not meet the eligibility period for receiving payments, such as 8 years. And if an employee sent from Austria to Japan receives a withdrawal lump sum payment for the insurance premiums they paid during their stay in Japan, that period will no longer be counted as a pension contribution period. And in addition, that period will no longer be able to be counted towards the total. So we need to think about which way it's better, to receiving the withdrawal lump sum or application of this agreement, depending on the case. And the third one is potential administrative challenges. Differences in administrative process and documentation required between Austria and Japan could create delays and misunderstandings, especially during the initial implementation phase. And about health coverage overlap. Overlapping health insurance requirements might lead to higher contributions or administrative burdens for employees and employers, particularly in cases where both countries' medical insurance applies. So, next topic is practical questions. So, we have, as I said, we have received some questions before this seminar, and I would like to mention some of those questions. So, scenario is following. An individual residing in Austria worked in Tokyo for one year in the 1990s and contributed to the Japanese employee pension system during that time. Apart from that year, this individual has worked in Austria the entire career and contributed to the Austrian pension system. So he will not be coming to Japan again. So this 1 year stay is the only time in Japan. So question is, can that individual claim a Japanese pension based on this 1 year of contributions after the agreement comes into effect? In this case, so the answer will be, it is probably possible to claim a pension for 1 year. I said probably because the interpretation of each article has not been clarified and we cannot be 100% sure, but there are two provisions that we can refer to in this agreement. One is Article 3, persons covered, and it said that persons who are or have been subject to the legislation of one or both countries, one of the both contracting states, is covered by this agreement. So someone who have been subject to the legislation of either of the country, he will also be subject to this agreement. And furthermore, Article 26, paragraph 2 states that in the implementation of this agreement, periods of coverage completed before its entry into force shall be taken into account for establishing entitlement to benefits by virtue of this agreement. So looking at these provisions alone, it reads as if a pension claim can be requested. And I have also discussed this point informally with the person in charge at the Japanese pension office. And the response was basically the same. But they also said that they cannot be 100% sure because before execution, there is not enough information, even for them. So I hope to be able to update further practical points after it takes effect. And question number 1, example number 2 is similar case as number 1, but this is also one of the questions we received. So scenario is an employee transferred by an Austrian employer to Japan has been working in Japan for 3 years at the time the Social Security Agreement comes into effect. And he is expected to remain in Japan for an additional 5 years. Question is, how is the avoidance of double coverage addressed, and how is the total period of coverage calculated? So let's think about the current practice. So before application first. So while in Japan, he is in Japan, he continues to pay social insurance premiums of Austria and is also required to pay social insurance premium in Japan. And as a result, he has to pay double. And furthermore, the social insurance premiums paid while in Japan are not counted towards the total for the period in Austria. And as a result, he does not meet the eligibility requirements for receiving a pension in Japan because he has not paid for 10 or more years. And after application of this agreement, as a result of the agreement coming into effect, he will only be liable to pay Japanese social insurance contributions for 5 years from the time the agreement comes into effect in order to avoid double payment. And as a result of the totalization provision, he will be able to receive a Japanese pension if the total period will become 10 years or more. And the calculation of how many years he will be able to receive a Japanese pension is probably 8 years. So 3 plus 5 years. But strictly speaking, we will need to wait for future interpretation to see how this will be implemented. And most probably this will be 8 years. And finally, about question number 3, this might be typical question also for agreement with other countries. The scenario is an employee assigned to Austria from Japan was expected to stay for more than 5 years, but returned to Japan earlier than planned. So the period of assignment did not exceed 5 years. And question is employee exempt from joining the Austrian social security system as the period of stay did not exceed 5 years? The answer is no. If the period of assignment to Austria is expected to be 5 years or less from the beginning, then the employee will be exempt from joining the Austrian system. For employees whose period of assignment to Austria is expected to exceed 5 years, even if the period of assignment does not end up exceeding 5 years, they will not be exempt from joining the Austrian system. But they will be exempt from joining the Japanese system. Yeah, but again, so all those practical questions, we need to wait for further information. Because, so far we just have provision of this agreement and not enough information. Yeah, and that concludes my presentation, and I focused on the basic information, but I also touched on some points that could cause problems in practice. And I think that discussion about interpretation and application will continue to progress in the future. So let's keep a close eye on them together. Thank you very much.
So for us, it's really important that we could demonstrate that, it is moving. This year, there was a real milestone. It was signed. It was ratified by the 2 parliaments. So it's really up to us to follow this development and see when it enters into force, when the procedures are laid down, that we follow up with a similar webinar or more information done also in newsletters or frequently asked questions kind of. And with that having said, thank you all very much. Thank you also Tsukamoto-san, of course, for joining us here today. We are, of course, your office here in Japan, available at any time. So if you have any other questions, legal or otherwise, please feel free to message us, to contact us by email or phone. And with that having said, thank you very much for joining us today. And I will use the mailing list that we have now to inform you of any updates. Thank you very much for joining us today here at Advantage Austria Tokio, Außenwirtschaftscenter Tokio der Wirtschaftskammer Österreich. Danke.